My Lord, I appear on behalf of Mr. Geddes, the appellant. My learned junior, Mr. Khan, sits behind me, and my learned friend, Mr. Waite, appears on behalf of the Secretary of State for the Home Department. Just as a matter of housekeeping, if I can go through the various bundles and documents just to make sure that you have got copies of them, my Lord. There should be a core hearing bundle of 168 pages, including skeleton arguments and the claimant's cross-referenced replacement skeleton argument.
Yes.
A supplementary hearing bundle of 222 pages.
Yes.
An authorities bundle of 300 pages.
Yes.
And a supplementary authorities bundle of 41 pages.
I don't think we have that. I don't have that. I can't imagine what supplementary authorities would be, but anyway, we don't.
Oh, my apologies, they can be handed up. They're simply if I can hand them up to you, they're just further legislative provisions and explanatory notes. And in addition, today I handed up a claimant's note on legislative development. Now that's nothing more. That's obviously been seen by my learned friend, and it's a slightly updated version of what was before the learned judge at first instance. And it's simply what it seeks to do is to bring the relevant provisions into one document to make it a little easier to navigate, and it's cross-referenced to the authorities and supplementary authorities bundle. So it doesn't sort of add anything specifically, it just is to assist the court in navigating the various statutory provisions.
All this is set out in the judge's judgment, isn't
it? It is, my Lord, but it may be relevant to look at the statutory development and look at the explanatory notes. So that's simply for your assistance. There is finally there's a provision handed up by my learned friend, which is section 81 of the Nationality, Immigration and Asylum Act, and that also is accompanied at the back of the claimant's legislative development note by the earlier versions of that particular provision in case they become material.
Right.
So those are the housekeeping matters, my Lord. Your Lordships and your Ladyship will see that this appeal turns on a fairly narrow point of statutory interpretation, and so the background to the appeal is instructive only up to a point and is largely non-contentious. So what I propose to do with your Lord...
I do want to ask about the background to the appeal. Maybe Mr. Waite can help us, but why on earth did the application for permission to appeal to the Supreme Court take 4 years to be looked at after the KO Nigeria case was decided? I simply don't understand it.
My Lord, I don't have an answer to that. I simply don't know either.
Yes, my Lord, I don't know. I will look into it if I may.
It was not the appellant's fault. Why should he chase it? But it's scandalous, really, that something like this should just disappear down the back of a cupboard or electronic equivalent for 4 years.
Yeah, yes, my Lord. It was certainly surprising when I took over the case. I was quite surprised. it's probably not material to the point we are dealing with, in the sense that you'll see that this is a case, and I'll take you through it very briefly, if I may. This is a case against, as you'll see, a judgment of Mr. Justice. It's an appeal, rather, against the judgment of Mr. Justice Laing, dated the 22nd of January 2024. You'll see that judgment at page 65, beginning at page 65 of the core bundle.
Yes, you can take it. We've read that and the skeleton arguments.
I'm most grateful, my lord. Would it then be helpful? I can take you very briefly through the background if that is of assistance, or if that's simply,
as you say, the background really is neither here nor there. The judge's section-headed background sets out the facts. There are two wrong dates in paragraph 5, but they're sort of obvious, and I've corrected them, but we don't really need any more.
I'm most grateful for that indication, my lord. Then what I propose to do, initially I was going to take you through the background if you required it, but the second thing I was proposing to do is simply to take you through my legislative development note, which will give you, I hope, a fairly comprehensive understanding of how the relevant provisions, which are 78, 79, 82 and 104 of the Nationality, Immigration and Asylum Act, how they came to be in the form that they were at the material time. And then I will proceed to make fairly brief submissions in support of the appellant's appeal. So if one turns to the first page of you'll see that the statutory development notice set out the legislative provisions should be highlighted in yellow, and the relevant explanatory notes, such as they are just in normal form. The first provision is Section 58 of the Immigration Act, which can be found in the Supplementary Authority bundle at page 1. It's on the first and second page.
Well, as you've thoughtfully produced this document with all the sections set out, should we stick to your document rather than?
Yes, certainly. Yeah. You'll see that the relevant cross sections or the relevant cross references are in my document. Yeah. So you'll see that the first provision is the predecessor provision to Section 104 of the Nationality, Immigration and Asylum Act, and you'll see that the relevant portions of it are highlighted in black there, or emphasised in black. An appeal is not to be treated as finally determined whilst a further appeal may be brought. 7, if such a further appeal is brought, the original appeal is not to be treated as finally determined until further appeal is determined withdrawn. Then if we move to Section B at the bottom of page 2, the original scheme of the Nationality, Immigration and Asylum Act as it was originally enacted, you will see there Section 82, the right of appeal, where an immigration decision is made in respect of a person, he may appeal to an adjudicator, and then it says in this part, immigration decision means, etc., etc. And that goes through various iterations. We will only draw your attention to the relevant versions of it. Then you will see that there is at page 4 of my notes, Section 83, which is a different route of appeal. So there are two routes of appeal, one under Section 82 and one under Section 83. And you'll see that Section 83, as it was originally enacted and remained in force, I think, until 2014, reads, this section applies where a person has made an asylum claim and his claims have been rejected by the Secretary of State, but he has been given leave to enter or remain in the United Kingdom for a period exceeding 1 year, or for periods exceeding 1 year in the aggregate. And then 2, the person may appeal to an adjudicator against the rejection of his asylum claim. And we see the explanatory note with that attached to that provision. I've emphasised in bold paragraph 6 of my note. There is no right of appeal under section 82 for a person in this position, and the purpose of this provision is to provide a specific single issue asylum appeal. So right up until 2014, there exists these two avenues of appeal. One of which, and the primary one of which, is under 82(1) in its various iterations. Then moving on to paragraph 7 of my note, section 78 and 79 over the page, says while a person appeal under section 82(1) is pending, he may not be removed from the United Kingdom in accord with the provision in the Immigration Acts, or be required to leave the United Kingdom in accordance with the provision of the Immigration Acts. And then it goes, in this section, pending has the meaning given to it by section 104. Section 79 over the page, on page 5 of my note, a deportation order may not be made in respect of a person while an appeal under section 82(1) against the decision to make the order could be brought, ignoring any possibility of an appeal out of time with permission, or is pending. And again, in this section, pending has the meaning given to it by section 104. Now, although there are slight amendments to, I think, section 79, in material part, they remain the same throughout. And they obviously raise the statutory bars both to removal and, perhaps even more significantly, to the very making of a deportation order. And of course, you'll have noted from the background material that what was in issue here was a deportation order which would be made under the discretionary scheme, not under the automatic deportation scheme. Then skipping on to paragraph 10, we then have section 104 as originally enacted. An appeal under section 82 is pending during the period beginning when it is instituted, and B, ending when it is finally determined, withdrawn or abandoned, or when it lapses under section 99. In section 2, an appeal under section 82(1) is not finally determined for the purposes of subsection 1b, where a further appeal or an application under section 102(2)(a) has been instituted and is not finally determined, or withdrawn or abandoned, or may be brought, ignoring the possibility of an appeal out of time with permission. And then one goes down to paragraph 11 and sees the relevant explanatory note, and I've highlighted the relevant sentence there in bold. It remains pending until the time limit for taking it further expires, or until it has been finally determined, withdrawn or abandoned. Now, as I understand the respondent's case, I don't think it's disputed, though the respondent will correct me if I'm wrong, that as it was originally enacted, it was any onward appeal. There was no restriction. It didn't say that the onward appeal wouldn't include an appeal to the Supreme Court. The issue, I think, comes with the subsequent versions of section 104, and that, of course, would seem to align with the one authority, although it's a somewhat thin authority, which is to be found on this point, and that is in the supplementary bundle, if you
Is this the Kenya case?
Yes, the Kenya case.
The judge refers to that.
Absolutely, absolutely. And I put it in the supplementary bundle on reflection because I thought it should, it's something that you should at least have sight of. But I think both parties recognises it's not a very strong authority because
it's an authority on what the position was under the versions you've just shown us.
Absolutely.
Presumably influenced the change made in 2005.
Well, it's. I will come to that, right. my lord. It's in any case clearly not a full determination, which has gone into the matter. It actually says at some point, well, we've not really fully explored the matter. It was simply conceded by, I think, counsel for the Secretary of State at that stage. But I think neither party to today's appeal makes any reference to it other than as background, and as a rather thin background at that. Then moving on, back to the legislative development, there's section B, the subsequent relevant amendments to section 104. There was a first amendment in 2005, and this is the amendment which the learned judge at first instance said indicated a profound change. And I will have submissions to make in relation to that. You will appreciate, my lord, that this was in the context of the gradual sort of changing and the institution of the unified, or moving towards a unified tribunal system, which was instituted under the Tribunals, Courts and Enforcement Act 2007. And this was one of the stages prior to that. So it makes provision in the relevant sections for various types of applications and appeals, including an appeal to the Court of Appeal. The section 103A to 103E can be found, and I've not reproduced them here, but they can be found for your note at the supplementary authorities bundle, pages 22 to 26, just as a background. But you will see, my lord, that set out at paragraph 13 is the explanatory note to the Immigration Treatment of Claimants, etc. Act 2004, Schedule 2, which is paragraph 20 of which inserted the relevant amendments to section 104. And you will see that there is nothing there which indicates and this will be one of the points in due course that the claimant will be making, that indicates the profound change which the judge at first instance said had taken place. Moving...
Is the position that until 2010, the term finally determined was not defined?
Well, it does say in the 2005 version, the one that was at paragraph 12, it does say an appeal under section 82(1) is not finally determined. Well,
oh, I see. Yes,
so,
it was defined in that way.
Yes, throughout there is some definition of finally determined, but paradoxically, and perhaps significantly, it's always finally determined is not positively defined. It's negatively defined, and again, that is a point that I will come back to in due course. And it is perhaps significant that it is negatively defined. But the point I would draw your attention to for later note is that the explanatory notes in relation to the change to 104 in 2005 do not in any way recognise that a profound change has taken place or that a restriction of an established entitle or of an entitlement to a statutory bar has been removed.
Or can that affect the correct interpretation of the language Parliament used?
It's certainly there is, of course, there is an authority, my lady. Just turn it up in the authorities bundle at page 76, the relevant section, extract of which, and it's one that is at 79, and it says what assistance the explanatory notes can be.
Is that Westminster and Nash?
Yes, yes. And so the explanatory notes, at least as I have read this judgment, and I submit that is that, of course, as I've read it, it's neither here nor there. I submit that
yes.
I submit that the explanatory notes drawing attention. Let me just read that passage, if I may. It's at it starts at F. At 79. Again, there is no need to establish an ambiguity before taking into account the objective circumstances to which the language relates. Applied to the subject under consideration, the result is as follows. Insofar as the explanatory notes cast light on the objective setting or contextual scene of the statute and the mischief at which it is aimed, such materials are therefore always admissible aids to construction. They may be admitted for what logical value they have. Used for this purpose, explanatory notes will sometimes be more informative and valuable than reports of the Law Commission or advisory committees, government green papers or white papers, and the like. I submit, therefore, that that's authority for the proposition that the explanatory notes as aids to construction are in a slightly unique position in that you don't necessarily have to pass through the gateway of pepper and heart, etc., in order to draw upon them and for them to...
Well, no, you don't, because they're not statements made in Parliament, so pepper and heart's not obviously relevant.
I'm grateful, my lady, but they simply can be used, they can be used and are properly used in conjunction with the statutory language. Of course, they don't displace... I'm sorry.
Well, I mean, but what Lord Laing said in this passage is actually quite limited. That you can look at the explanatory notes to help you with the objective setting or the contextual scene or the mischief at which the statute's aimed. He's not saying you can use the explanatory notes to control the meaning of the statutory language, is he?
I accept that, my lady, and I'm not suggesting that the explanatory notes can do that, but insofar as there is some uncertainty, they certainly, what is said or what is not said in the explanatory notes may be illuminating, and I'd simply rely upon that for that proposition. But I recognise it goes no further than that. Obviously, the starting point must be the statutory language.
Yes.
And I'm not suggesting otherwise.
Well, you included in the bundle and supplementary bundle a great many explanatory notes,
yes.
Explanatory memoranda. It would help if you told us in a particular case what does it reveal to us that is not revealed by looking at the statute itself.
Yes, yes. All right, well, in relation to in relation to the change which took place in 2005, my point is simply in relation to the explanatory note is that there is no recognition of the supposed profound change which is said to have taken place, and in the explanatory note. But I accept.
Well, you wouldn't expect the explanatory note to say this is a profound change.
Well, no, but my submission is that what one would expect if there was going to be a significant restriction of a pre-existing entitlement, which would be the statutory protections of 79 to 78. If there was a restriction of that, one would expect that in the explanatory notes. That's the claimant's submission. I think the height of the claimant's submission, and no doubt your lordships or your ladyship will be with me or not with me on that point. And I think that's the height of what the claimant seeks to say in relation to that.
What the explanatory note seems to imply is that paragraph 20, it's presumably paragraph 20 of a schedule to the 2004 Act.
Yes, it's schedule. I think it's paragraph
Schedule
20.
2.
Schedule 2, yes.
Right, so it's paragraph 20 of Schedule 2 appears to have made more than one amendment to the legislation. And what the explanatory note focuses on is the change to the powers of the Lord Chancellor to make rules about the procedure in the tribunal. But the fact that the note focuses on one aspect of the amendments which were introduced by paragraph 20, I mean, without knowing how many amendments were introduced by paragraph 20, it's difficult to see what significance one can attribute to paragraph 122 of the explanatory notes.
My lady, I have to, and I do have to concede also, and perhaps building upon what you're saying, that the explanatory note, such as it is extracted there, is not actually especially clear. It does seem to go in different directions, and I accept that.
All right, well, shall we move on?
Indeed, indeed. Then moving to paragraph 15, the version of paragraph 104, although it was slightly, section 104 of the Nationality, Immigration and Asylum Act 2002, which in substance is as it remains, although there is one further amendment to it in 2004, but in substance, as it remains at the relevant time, was introduced, and it was given effect from 15th February 2010, and it reads, an appeal under section 82(1) is pending during the period beginning when it is instituted and ending when it is finally determined, withdrawn or abandoned, or when it lapses under section 99. An appeal under section 82(1) is not finally determined for the purposes of subsection 1b, while A, an application for permission to appeal under section 11 or 13 of the Tribunal Courts and Enforcement Act could be made or is awaiting determination. B, permission to appeal under either of those sections has been granted and the appeal is waiting determination. Or C, an appeal has been remitted under sections 12 or 14 of that Act and is awaiting determination. You will then see, moving forward to paragraph 20 of the legislative development note, how that is amended in 2014, and you'll see that the relevant section 104.2 remains the same. By that time, there is a new version of paragraph 82 in place, which was inserted by section 15 of the Immigration Act 2014. and that is contained at 17 of the legislative development note. One of the things that the claimant will say, and of course this is, I think, the key difference between, not the claimant, the appellant rather, and the respondent, is that the list of onward appeals detailed in paragraph, I apologise, in section 104.2 as amended, is illustrative, not exhaustive, but I will come back to that in a moment. The last two provisions which are of relevance are sections 13 of the Tribunal Courts and Enforcement Act 2007, and you will see in particular subsections 11 and 12. The court, 11 says, before the upper tribunal decides an application made to it, this is at paragraph 27 of my legislative development note.
Yeah.
Before the upper tribunal decides an application made to it under section 4, the upper tribunal must specify the court that is to be the relevant appellant court as respects the proposed appeal. And that picks up on what's said at section 13.1. It then goes on, section 13.12, the court to be specified under subsection 11 in relation to a proposed appeal is whichever of the following courts appears to the upper tribunal to be the most appropriate. A, the Court of Appeal in England and Wales, B, the Court of Session, C, the Court of Appeal in Northern Ireland. 13, in this section, except subsection 11, the relevant appellant court as respects an appeal means the court specified as respects the appeal by the upper tribunal under subsection 11. The reason I focus upon section 13 of the Tribunal Courts and Enforcement Act is because that deals with the onward appeals from the upper tribunal to the Court of Appeal. You will see then finally, penultimately rather, the relevant explanatory note for that, and I've highlighted the section insofar as it's relevant. I say highlighted, I've emboldened it. That's at page 13 of my note. This provision is intended to deal with situations where it's not obvious which is the appropriate appellant court, e.g. where an appellant has moved from Scotland to England or vice versa, or in order that linked cases can be dealt with in the same court. And then finally, I've not set them out, but there are the leapfrog provisions which were introduced in 2016. I recognise that that is after the relevant amendments to section 104, and I will come on to those in due course. But I've not set them out in full, but they can be found at the authorities bundle, pages 65 to 67.
Yes.
So that is the somewhat of a whistle-stop tour through the legislative background and development. The appellant has three simple submissions, relatively simple submissions. The first turns on the meaning of, the natural meaning of finally determined in section 104.1, and indeed not finally determined in section 104.2. Secondly, the second point deals with the supposed exhaustive nature of the specified appeals in 104.2 of the 2002 Act, said to arise under the expressio unius principle. And thirdly, the legislative anomaly created by the institution of the leapfrog appeal. And if I can take each of those in turn. So first, focusing upon the term finally determined. The appellant submits that the natural meaning of that phrase is that until an appellant has exhausted his or her rights of appeal, an onward appeal, an appeal instituted under 82.1, as opposed to being instituted under 83, remains open to further challenge and cannot be said to be finally determined. Determined, yes, but not finally determined. I recognise that that bold assertion in and of itself doesn't take matters further, but then one needs to take into account, in order to appreciate that that natural meaning is not displaced, a number of other factors. As I've said, I take it that the respondent does not dispute, although he'll correct me if I'm wrong, that as originally enacted, the meaning of finally determined operated in the way that is suggested, and that the statutory protections afforded under Section 78 and 79 covered all onward appeals. It's said, as I've already alluded to, that there was a profound change in April 2005, the April 2005 amendment to the terms of Section 104, such as to depart from the normal and natural meaning of the terms finally determined. And this is going to be a matter of your lordships, and your ladyship will either be with me or against me.
That's correct.
My submission is that there is no evidence of such a profound change. There's no evidence in the explanatory.
What would evidence look like?
Well, I've already drawn your attention to the explanatory note point, and you either see that or not. In addition, my submission would be is if there is a key statutory protection to be removed or restricted by subsequent amendment, one would expect that it would be done so explicitly and not by mere implication. And that if there is any interpretive doubt, it should be, it's not quite the contra proferentum rule, but it should be interpreted in favour of parties whose rights are allegedly being restricted. Further, it is noteworthy that the terms of Section 104, in all of its amended forms, remain in the negative. It says it will not be treated as finally determined in Section 104.2. It does not say what will be treated as finally determined. If it had wanted to provide an exhaustive list, Parliament could just have easily added a further line to the provisions specifying that once a substantive decision had been received from the relevant appellant court, an appeal would be treated as finally determined. And that is in the context of the fact that the predecessor provision clearly did not treat as finally determined the delivery of a substantive decision to the Court of Appeal, and did cover or did extend the statutory protection to an appeal to the highest court in the land. Secondly, in applying the principle of legislative interpretation expressio unius et exclusi alterius, my Latin has not, if I've not sort of made too much of a mess of that, it is said that since the legislator has chosen in Section 104.2 to specify certain types of onward appeal but not others, those other appeals, namely appeals to the Supreme Court, fall to be excluded from its scope. The expressio unius principle is, of course, easily displaced, and that can be seen from the commentary and the relevant cases which are detailed in the extracts from the relevant extracts from Benyon, and needs to be read alongside the principles governing incorporation of statutory terms by reference and the reading of a complex statutory scheme in pari materia as one system. The appellant recognises that the focus of the judge at first instance in applying the expressio unius principle is on Section 104, but it must also, if it is to successfully be prayed in aid, the appellant says, take into account the terms of Section 13 of the Tribunal Courts and Enforcement Act 2007, the purpose and logic of which it incorporates. When turning to Section 13 of the 2007 Act, it is clear that the purpose of that section, and in particular of subsections 1311 to, section 1311 and to 1313, is to remove uncertainty or dispute between the three specified appeal jurisdictions in relation to the destination of the appeal, which makes perfect sense because at that point of onward appeal, there is a transition from a unified to a geographically tripartite system. It's also a reading which is amply supported both the terms and the sense of the provisions themselves and indeed the explanatory notes. So there is no warrant, the appellant says, for treating Section 13 as placing additional or bespoke restrictions on the ultimate extent of onward appeal. Similarly...
Well, hang on. The Section 13, all that Section 13 does is it defines the right of appeal from the upper tribunal to this court or our Northern Irish or Scottish equivalents. That's all it does. The point you really have to make is the terms of 104.2 as amended.
Yes. I accept that, my Lordship, and that's why I began by saying I recognise that the focus of the application of the expressio unius principle in the court of first instance was 104. My argument is, and again it's going to be a matter of you're either persuaded by it or you're not, is that taking the two principles of incorporation by reference and in pari materia together, that one has to also bring in one does bring in the rationale of the statutory provision which is being which is being referred to, and that also, in order for the expressio unius principle to bite in respect of 104.2, it must also bite in respect of 13, because the rationale of that statutory provision has been imported.
Sorry to interrupt. Could I ask a question, please? Section 104 refers to an appeal under Section 82, subsection 1.
Yes.
And it tells you when an appeal under Section 82, subsection 1 is pending.
Yes.
Section 82 defines an appeal under Section 82, and that's, in brief, you get that from the heading, right of appeal to the tribunal.
Yes.
Now, the earlier provision of section, the predecessor provision, so for example, Section 58, referred to a further appeal.
Yes.
Now, doesn't that distinguish between the right of appeal, the initial right of, statutory right of appeal to an immigration tribunal or adjudicator, and a further appeal which is made outside the tribunal system?
My Ladyship, if I've understood, my reading, and it may be wrong, but my reading of that provision was that was carried over into the original version of 104.
Yes.
And the original version of 104 also uses a further appeal.
Yes, exactly. So the legislation originally made provision for the statutory appeal to be deemed to be pending while a further appeal could be brought or was brought. But the current version of the legislation makes no reference to a further appeal. It focuses on an appeal under Section 82(1), which is the scope of which the scope of that appeal is defined by Section 82, i.e., an appeal within the tribunal system.
Well, I certainly have to accept that it's an appeal within the tribunal system.
Right.
The appellant's position is that and I know this is again a point of difference between the appellant and the respondent, that is a signposting provision. So what it talks about is a type of appeal which is instituted under 82(1), and I accept that 82(1), and if one looks at 81, it's clearly an appeal to the first tier tribunal. But that, the specification of an appeal under 82(1) is to distinguish it from an appeal, from the route of appeal under 83. So it's a signposting provision, because there are two routes of appeal up to 2014. I hope I haven't...
Yeah, but there aren't two routes of appeal now. So the current provision refers to an appeal under Section 82(1), and it tells you when such an appeal is still pending.
Yes.
And unlike the earlier versions of this provision or
yes.
the equivalent provision, there is no reference in the current version, Section 104, to a further appeal, in contradistinction to an appeal under Section 82, subsection 1.
Yes.
So what significance do we attribute to that missing element?
Well, when that was removed, that reference to further appeal, it was removed originally in 2005, which is why the judge of first instance says there was a profound change. But at that stage, there were still two routes. There was a route under Section 83 of appeal under Section 83. And so the appellant's submission is that the reference to 82(1) is a remnant of that, and it's a signposting provision. So it's the type of appeal which is instituted under 82(1), but it doesn't say anything about what happens later down the track.
But there's nothing now other than an appeal under Section 82(1), as I understand it.
I accept that, and I think
So what Section 104 is telling us about is when an appeal under Section 82(1) is pending, and there is no reference in the current version of Section 104 to a further appeal. The only references to appeals in Section 104 are to an appeal under Section 82(1).
Yes, I accept that, my lady, and I think the height of the appellant's submission must be that looking at the legislative development, that is a remnant of what went before, and that for that reason, it is not material to the interpretation. Now, again, it's one of these circumstances where you're likely to be either with the appellant or against the appellant on that interpretation.
But leaving aside the difficulties I have with that approach, how is a person who looks at Section 104 now supposed to understand what it means? Because what you're really saying is they've got to look at all the previous legislative history.
Well, my lady, I accept that that's a difficulty, and all I can say is that it's a difficulty which crops up frequently in this area of law. Given that we're trying to determine, or your lordship, your ladyship and your lordships are trying to determine the intent of Parliament, I accept that is a difficulty, but it certainly doesn't necessarily go to what the intention of Parliament was in making those in terms of various
situations. Where are we to gather Parliament's intention, other than from the words which Parliament has used in these provisions?
Well, my submission is that one therefore does need to go back to the way that the legislation has developed, and if there's a clear rationale as to why a particular route of appeal has been identified, and there's no, then one can be informed by that.
We have to focus on section 104 as it exists
Yes.
now and has done since 2010. And if you just look at it, and it begins an appeal under section 82(1). That is nowadays appeal to the first tier tribunal, originally to the adjudicator. Nothing turns on that chain. But that's appeal now to the first tier tribunal. It's pending during the period beginning when it's instituted and ending when it's finally determined. If the section stopped there, you would say that the moment the FTT decision is promulgated, that's it. That's the end of the road. But it doesn't stop there. You've got the extension, if you like, provided for by subsection 2. And that says that the appeal to the first tier tribunal is not finally determined while an application for permission to appeal to Court of Appeal, Court of Session could be made, or the application has been made and is awaiting determination, or the application for permission has been granted and the substantive appeal is waiting to determination. I think we can forget about remittal.
Yes.
Well, what's wrong with that?
I accept that for the appellant's interpretation to work, it would have to press a slightly different interpretation of 104(1), namely that finally determined in its normal meaning does not just, if there is a further appeal that can be pressed, although it will be determined by the first tier tribunal, it wouldn't be finally determined because it could go on. So in other words, without 104(2), the meaning of that provision, in slight contrast to what, well, in significant contrast to what your Lordship has suggested, would mean that it wasn't finally determined once a decision was given by the first tier tribunal. It was determined, but not finally determined. And that's the natural meaning point. And when that is appreciated, and again, your Lordships and your Ladyship will either be with me on this point or against me, then it illuminates or it casts 104(2) in a slightly different light, and it becomes not quite illustrative, but certainly not exhaustive.
104(2) could have gone on to say, can't remember under what provision the Supreme Court has jurisdiction, but anyway, it in the old days, the House of Lords, it was the Appellate Jurisdiction Act, but it could have gone on to say, an appeal to Court of Appeal, Court of Session, Court of Appeal, Northern Ireland, has been determined, but an application for permission to appeal to the Supreme Court has been made and is awaiting determination, something like that.
Yes.
But it doesn't.
No, I accept that, and I accept that that's one of the hurdles that the appellant has to overcome, and of course that relates to the point that I've made, that it is noteworthy that it's defined in the negative. So it's not finally determined, and it could easily have said that once a substantive decision is made by one of the relevant appellant courts, it will be finally determined. But it's chosen not to do that. So I suppose the appellant's position is the reverse of what your lordship is suggesting, and that given that this is a significant restriction of an entitlement to a statutory bar, one would have expected that.
All right. Do we get any help from Niaz, which the judge referred to?
Well, my submission in relation to Niaz is that Niaz is a matter concerning judicial review, and I sought to distinguish it at first instance on the basis that what's clearly being referred to in the statutory provisions is an appeal, not a judicial review, and there is obvious reasons why that would be the case, because although of course there are always ways in which once an appeal is determined that it can potentially be reopened, the provisions I think are quite clear that if permission is refused or an appeal is substantively determined, that is what they're focusing on. Judicial review is sort of out with that scheme, and so my submission on that point is simple, and I think you probably have it in my skeleton argument.
Nothing would ever be, if JR were included, nothing would ever be.
Well, this is the difficulty. Yes. So it's clear that why that choice was made. The final point that the appellant would seek to press is, and I recognise it has to be dealt with some caveats and delicacy, is that in 2016, of course, there is the introduction of the leapfrog provisions. So if the respondent's interpretation, bearing in mind that this does postdate the relevant amendment to 104, but if the respondent's interpretation is correct, it will follow that appeals which raise the most significant and profound points of law, such as to justify the leapfrog procedure, simply fail to attract the statutory protections of Section 78 and 79. And the appellant says that creates a statutory anomaly. And now it was.
But would it in practice? I mean, I've been involved both in the High Court with leapfrog cases and in the Employment Appeal Tribunal in the days before the amendment, where everybody wanted there to be a leapfrog appeal, but there just wasn't. Surely the answer to your anomaly is in practice. The party who's unhappy with the upper tribunal decision, but says there's a point of law fit for the Supreme Court, applies to the upper tribunal for a certificate and also for a stay. And if the upper tribunal refuses a certificate, that's the end of it. You can't get around that for a leapfrog. But if the upper tribunal grants a certificate, which I guess it does about once a year, it could grant a stay. What's the problem?
Well, my lord, that's and that's certainly something which was obviously in the judgment at first instance. But as I said to His Lordship, Mr. Justice Laing, that could be said of any appeal to which the statutory protection didn't apply. The statutory protection means that is not required, and so it doesn't actually deal with, in my respectful submission, the anomaly which is created. Because, of course, if there was no statutory protection, then a stay could always be applied from any of the courts. So the statutory protection, the chain or the protection it affords is that a particular appellant doesn't need to apply for a stay. And that's the only distinction between having the statutory protection and not having the statutory protection.
But if you look at the terms of Section 78, Parliament's been reasonably careful to say that while a person's appeal under Section 82, subsection 1 is pending, he may not be blah, blah, blah. If your argument's right, Parliament could very easily have said, while a person's appeal under Section 82, subsection 1, or a further appeal is pending, blah, blah, blah.
Yes, that is.
So what one has got to understand in order to understand the scope of the statutory stay is what an appeal under Section 82, subsection 1 is. And that's defined in Section 82.
I accept that, my lady, and I can only sort of go back on the arguments that I've already advanced in relation to Section 82, 1, and there being different routes of appeal, and you will either be persuaded by that or not. But I do accept that the terms 82.1 are specifically referred to in sections 78 and 79. In relation to the final point, in relation to the leapfrog provisions, my lord, is that the judge at first instance, of course, said that it was noteworthy that the provisions were inserted without any consequential amendments to Section 104, which was, well, he used the term compatible, but I think probably he meant indicative, because he said compatible or more with Parliament having excluded onward appeals to the Supreme Court from the scope of 78 to 79. But the appellant submits that to the contrary, it's much more compatible with Parliament having recognised as correct the less restrictive interpretation of 104, since the appellant's interpretation, no statutory anomaly arises. I recognise that that's a slightly unusual way of approaching a subsequent statutory intervention, because it's more or less saying, well, the understanding of Parliament at the time of the overall statutory scheme at the time of the subsequent legislative intervention can inform what its intention was earlier, in respect of earlier interventions. But it is, at least in my respect for submission, persuasive. I think those are the submissions of the appellant, unless I can be of further assistance.
Thank you very much. Mr. Wayne.
My lord, yes.
We have your skeleton,
yes,
which is very helpful, and if there's anything you'd like to focus on which isn't there, then
I think the court has my points simply from the discussions which have occurred this morning. But I'll put it in a few sentences, if I may. That the purpose of Section 104.2 is to outline the additional circumstances in which a first instance appeal under Section 82.1 will be treated as not finally determined, despite the fact that that first instance appeal has been decided. So accordingly, if a specific avenue of appeal is not mentioned in Section 104.2, the pursuit of such an appeal will not prevent the Section 82(1) appeal from being finally determined. Sounds like a mouthful, but I hope it makes sense. It is in my submission important, as I think has been stated in court today, that it is important to recognise as a starting point that the Section 82(1) is the first instance appeal, and indeed the additional provision which was passed up today, which is Section 81, states in terms, it was passed up to the court, meaning of the tribunal. In this part, tribunal means the first tier tribunal.
Sorry, where's that?
Sorry, that was passed up as a late addition.
Yes.
It should be written bottom right-hand corner 16A.
I think it's a loose bit of paper. I'll put it loose anyway.
My lord,
Oh, I see.
it may have been attached to the back of the legislative note.
Yes, it was.
Because there's also the earlier provisions that I've included as well.
Yes, thank you.
The earlier versions.
So we have the definition of tribunal. In this part, tribunal means the first tier tribunal.
Yes.
And then moving to the provisions which you've already been shown in tab 3, page 23, which is section 82. And that's page 23, tab 3. There you have the definition of the articulation of the right of appeal, and it's the right of appeal to the tribunal due to section 82(1). That is unquestionably the first instance tribunal.
Yes.
So there's no right of appeal conferred in this section to any other body. Those rights of appeal are conferred elsewhere. So then the next provision to look at is page 17, just a few pages back. And as Lady Justice Laing, I think, has pointed out, it's section 78. But these are important words, section 78, no removal while appeal pending. But while a person's appeal under section 82(1) is pending, those are important words. It is again talking about the first instance appeal. And then moving on, finally, to section 104.
Well, actually, sorry, just before you get there, and there's a similar point can be made about section 79(1), which is the inhibition on making a deportation order. And again, it's the next page, page 20. Deportation order may not be made in respect of it while an appeal under section 82(1)
Yes.
may be brought, blah, blah, blah.
So it is the first instance appeal which under these provisions is suspensive. But then what section 104, I think my Lord Justice Bean has just already gone to this provision. Which is on page 27. I should have pointed out that section 78 also says that pending will have the meaning given by section 104, so that's what we're looking at now on page 27. Section 104, an appeal under section 82(1) is pending during the period beginning when it is instituted and ending when it is finally determined. As I think has already been pointed out, no mention there of onward appeal rights. And if the matter had been left there, in my submission, the exercise of an onward right of appeal would not have been suspensive. And that is the importance of section 1042, because its purpose is to make specific provision for additional circumstances in which the section 82(1) appeal will be regarded as not finally determined, namely the specific circumstances set out in that provision. We say the matter really is as simple as that. It is no more complicated than that.
Sorry to interrupt, Mr. Waite. The reference to a right of appeal under section 11, that's of the TCA, that's a right of appeal from the FTT to the upper tribunal.
It is,
Yeah.
yes.
We were referred earlier to section 83 of the 2002 Act, and I've forgotten about that. Was it a special provision for appeals in certain types of asylum?
Yes, it was which was not suspensive, and the reason they were not suspensive is because the individual had been granted leave.
So it would be a person who had got a relatively short period of leave and thought, actually, I'd rather have refugee status because it's more advantageous to me.
Yes, I think it was called ELR then or something, but
Yeah.
they would be given, still have the right to appeal against the refusal of asylum. In my submission, you're not going to be really assisted by delving into the legislative history, but it's actually entirely consistent with the Secretary of State's case, because the key point is that it has always been the case that section 1042 sets out the additional circumstances in which the first instance appeal will be treated as not finally determined. That's always been the purpose of that section. All that has changed is that Parliament legislated to narrow down those circumstances. That is all that has happened. And you will see that if you look at the legislative history. Just very briefly, we could look at page 30 in the authorities fund, tab 4.
The judge just set this out, isn't he? With the text
Yes,
in
he does.
2002, 2005, and 2010.
He does. But the same scheme is in operation from 2002. Section 1041 in its original form, which is on page 30, states it's pending during the period when it is instituted and ending when it's finally determined, withdrawn or abandoned. Left there, you would have no any onward appeal would not be suspensive. But 104 to performs exactly the same purpose in the original statute in its original form of defining the additional circumstances where the first instance appeal will be treated as not finally determined.
In the 2002 text, further appeal is not defined.
Absolutely. So it's any further appeal.
Yes.
And exactly the same structure was followed with when the change was first introduced. They brought in initially a unified tribunal system, but I won't go through that because unless you want me to, it's exactly the same point applies. Essentially, the first instance right of appeal from 2005 was to a unified tribunal, the Asylum and Immigration Tribunal. That was the first instance right of appeal. There was no right of appeal, onward right of appeal against that decision. There was a right to apply for reconsideration. There was a right for statutory review and reconsideration. And when an appeal, even when an appeal was reconsidered, there was then an onward right of appeal to the Court of Appeal. And I don't ask you to turn it up, but what the 2004 Act did was make equivalent provision to what currently exists, essentially for the first instance appeal by the Unified Tribunal to be treated as not finally determined when there was an outstanding application for reconsideration or where reconsideration had been ordered and there was a pending appeal. So it put in place equivalent provisions. In terms of the decision in NIAS, we say it was correctly decided, and it goes further than deal just with judicial review. We say that paragraph 20, it's in tab 13, paragraph 24 of that decision. That's page 34. About 2/3 of the way down that paragraph 24, sorry, on page 34, about 2/3 of the way down, there is also, in our view, no reason for assuming that the legislature intended section 104.2 to be merely a non-exhaustive set of examples. So effectively, the tribunal rejected a similar argument that was being made today.
Mr. Justice Laing again.
It is.
Yes.
I don't accept that the absence of special provision for leapfrog appeals to the Supreme Court amounts to an anomaly. It's consistent with the overall parliamentary intention that appeals to the Supreme Court would not be suspensive. So I don't say it's an anomaly. I accept Parliament could have made provision for it, but it hasn't. finally, I would just say this. It seems to me, on however you construe my learned friend's case, it comes down to an assertion that Parliament has either forgotten to mention the Supreme Court in section 1042 or considered that the suspension nature of an appeal to that court is so obvious that it doesn't even need to mention it. And if you see it in those terms, in my submission, it's just not credible. It's not a credible case to advance.
Have you or has your solicitor been able to find out about the 4-year delay in the Supreme Court?
My solicitor is quite new on this case.
Right.
So I was looking through the papers,
Yeah.
and I couldn't find the answer. I wondered if it was because it had been put behind another Supreme Court case, but I just don't know.
Well, it was behind, was it Agiarco?
Yes,
Or AO Nigeria or something.
It was,
Nigeria.
which was decided in 2006.
All we have from the Supreme Court is a single page at page 35 of the supplementary bundle, saying that permission to appeal be refused because the application doesn't raise an arguable point of law. This permission to appeal was adjourned pending the outcome of KO Nigeria, but that decision does not make it appropriate to give permission to appeal in this case, and that's 15th February 22, and KO Nigeria had been decided in 2018.
Which is extraordinary delay, I agree. I'm afraid I don't.
We don't
in
know.
that case, I don't.
All right.
I'm afraid.
And as we said earlier, it doesn't affect the outcome here, but it's certainly caused my eyebrows to shoot up to somewhere near the ceiling.
Yes.
Right. Any questions? Thank you very much. Yes. No need to repeat anything, but if there's anything to which you'd like to respond.
My Lord, I think you have the appellant's points. I don't think that I'm going to be able to assist you any further.
Well, thank you both for your concise and helpful submissions. We'll reserve judgment, I hope not for too long. As counsel know, we will send out a draft, not a draft in the sense that anything is to be re-argued, but simply to point out any factual errors like dates and so on, or any typos. We'll then hand down the judgment electronically. The other thing about the draft is that its contents are confidential to the appellant, his legal advisors, and the Home Office legal team and anybody else within the Home Office who has to know about the case before the decision is promulgated. Thank you very much indeed.